She was 9 months pregnant with cocaine, alcohol, and marijuana in her system, and by sunrise, someone was dead.
The only thing that she did wrong at the day and time was drive a vehicle
with cocaine, alcohol in her system, beer in the car, and there's a fatality as a result.
Yes, sir.
Can you please read to me what happened?
Yes, sir. This crash happened back on December 24th of last year. Officers were advised of a 4-vehicle crash at 5:37 a.m. on the 6300 block of I-45 South here in Harris County. Investigators observed massive damage on a Chrysler, indicating a head-on impact, massive force damage on a Mitsubishi, indicating a T-bone impact to the driver's side. Officers spoke with a HFD firefighter who was on his way to work and observed the Chrysler strike the Mitsubishi. The Chrysler cut in front of him, causing him to swerve to the right and hit an Amazon truck. He states that this defendant was the driver and sole occupant of the Chrysler, and the driver of the Amazon truck confirms the wheel witness's story and stated that he clipped the Chrysler as he was coming to a stop. The complainant was taken to the hospital where she was pronounced deceased. Officers observed an unopened beer can in the driver's seat of the Chrysler. This defendant stated that she was the driver and that she struck the vehicle. They observed a strong odor of alcohol on her breath, red glassy eyes, and slurred speech. She was transported to the hospital, and a DRE arrived, and she was Mirandized and she waived her rights. She stated that an SUV was stopped in a lane and she tried to swerve to avoid hitting it and then crashed into the other vehicle. She admitted to consuming 4 to 5 12-ounce twisted teas and smoking marijuana.
And alcohol in the car while she's driving.
Yes, sir. SFSTs were done. She scored 6 out of 6 on the HGN. She did not have vertical gaze nystagmus, and officers observed a lack of convergence. They were not able to do the walk and turn and one leg stand due to her injuries of a broken arm and sternum. There was a blood warrant and residual search warrant that were done, and her blood, Your Honor, came back at a 0.025 for ethanol, and she had, yes, 0.25, yes, sir. And then she had marijuana and cocaine in her system.
And what's the offer you worked out?
We worked out an 18-month probation offer with 7 days as a condition, Your Honor.
That's not the fact that there's a dead body in this case. Why is it not an intoxication?
It's a causation issue, Judge. We looked at it for an upgrade, is my understanding, because the other vehicle was on the roadway. Legally speaking, there's a causation problem, Judge, so that's why we came to the agreement that we have the families on board.
I'm not sorry, I'm not going to say it. You have a dead body here. She has cocaine in the system. She's got booze in the car while she's driving, and a dead body. I'm not down with that. No, we're going to have to do something else, but I would be remiss a week in jail where we have a dead body. That's
yes, sir.
And to me, just because you're 9 months pregnant doesn't factor anywhere in my mind, Ms. Sanchez. Ma'am, look at me. While you're about to give life, you took someone else's life. How many lives are now ruined because of this? Not only yours, how about everybody else? Every single day in Harris County, someone is maimed because of the DWI. It's sick that we lead the nation in fatalities. And I don't know why they can't prove causation to charge you with intoxication manslaughter. But to me, a week is insufficient. It's not enough.
Yes, sir.
So
we'll go back to the drawing board and get it reset.
But
yes,
I'm ready to set this case for trial now. So unless we can work something out today, I'm gonna say it gets set today.
yes, sir.
Okay.
All right, thank you, Judge.
Your Honor, I understand that a fatality did occur, but the reason why they weren't able to charge my client with intox manslaughter is because this accident was unavoidable. If you were
Unavoidable?
yes, sir. At the time of this accident, it was unavoidable. What ended up happening is that the deceased party spun out in front of her, and she was just going straight. The only thing that she did wrong at the day and time was drive a vehicle
With cocaine, alcohol in her system, beer in the car at a .20. let me ask you something. Have you ever done breath test? Have you ever blown into a breath test machine? Have you ever done those wet labs? You ever done that?
Okay.
I'm serious, really.
Okay.
Have you ever done it?
I'll go one further, Your Honor. Before being a defense attorney, I was a lieutenant with HPD.
Okay.
So I'm above and beyond. I spent 3 years doing accident division. So not only did I investigated these. So my knowledge is probably more superior than anybody in the room. I spent 3 years picking up dead bodies. And that is a true and factual statement I'm making before the court. So yes, sir, I have.
I did, as part of training when I was a defense lawyer, I went to these classes where we took the breath test machines apart, did all kinds of experiments, did these drinking wet labs where you drink and then you blow into the machine. And the one time we did it, we downed a bunch of booze and I blew into the machine and I was lit, right? And I blew a 14 and I was lit, man. And all I did was I blew a 14, right? 0.14. She's at a 0.2.
0.025, Judge. 0.025.
0.02.
Yes, sir.
Okay. I thought you said 0.2.
No, sir. No, it's 0.025 with the cocaine and THC.
No, so she's not 3 times or 4 times over the legal limit, yeah.
We were discussing about Ms. Sanchez. We were discussing when for you to do your jail time. Should we have you do it immediately to where you have the baby in jail? Is that cruel and unusual punishment? But then again, is a dead body cruel and unusual punishment? What's fair? What's not fair? I don't know. All I know is that you're charged with DWI. There's a dead body, but they just can't prove causation. And that's why you're not charged with manslaughter. But the fact remains is that we have a dead body. How do we reconcile that? You're pregnant now, and I truly hope that you've treated your body well throughout that pregnancy. Because if you haven't, and you've used anything while you're on probation, you're guaranteeing yourself a life of babysitting of a potential baby that will have developmental, potential psychological, physiological issues that you'll have to babysit for the rest of your life, which is punishment in and of itself. It's not fun. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you guys have worked out is 30 days in jail as a condition to probation for 18 months. As part of the probation, does she have any prior DWI staff?
No, Judge.
Any other criminal history?
Juvenile history only, Your Honor, but nothing DWI.
What all were you wanting done on the probation? Correct.
Yes, sir. We are asking for DWI education class, a victim impact panel, guardian interlock, no refusal, no drugs or alcohol, random UAs, 80 hours of community service, and a $300 donation to MAP.
Is this how you understand the conditions, Ms. Sanchez? I will keep you to it strictly. I'm going to monitor you myself. You will report to me here to the court so that I make sure everything gets done well. If you are not in compliance, I will issue a warrant for your arrest. You will be put into jail, and then you'll be facing up to 180 days in jail. If you test positive for alcohol or any kind of drugs, I will put you in a treatment facility in the jail. Do you understand, ma'am? No alcohol, no dope, no driving. You must have what does she have now? Does she have a scram right now? Do we know if she's had any violations while she's been on? I don't think so,
I
right?
haven't
She hasn't
seen
any
any,
violations.
Judge, no.
Okay.
She has a scram device at this time, Your Honor.
we're gonna have to figure out something about as far as the baby situation with the interlock or with the portable device. I will follow the state's agreement here. But like I said, I'm keeping you close to me. From now on, you'll be facing a minimum of 30 days in jail if you ever pick up another DWI. Do you understand? You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, if possible immigration consequence, you can be deported, excluded from the country, denied naturalization under federal law. Hey, if you can do the repeat offender DWI education class. Did you say victim impact panel?
Yes, sir.
How many?
One.
One victim impact panel. You will be required to do a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill those conditions. Guardian interlock, no drugs, alcohol, random UA. When are you set to deliver, ma'am? What day?
August 28th.
When do you think we should do the time?
If I could request anything, Your Honor, it'd be the beginning of the year, in January 2025, the start of the year. That gives her time to nurse her baby and everything else.
She must get it done within 6 months. Okay. All right, ma'am, how do you plead to the offense guilty or not guilty? And we'll find you guilty. We'll send you to the disagreement. Good luck to you, ma'am.
Thank you, Your Honor. The state will pass the witness.
So that now it's what, 11:02. Okay, Mr. Flood, you ready?
I'm sorry, did the state pass?
State pass witness.
All right. Yes, I'm ready, Judge.
Okay.
See where to begin. You saw the video that we all watched of you approaching Mr. Martinez, right? Yes, sir. And despite your insistence on what you're telling, well, you told the jury that you asked him how much he had to drink, or if he had been drinking, right? That he admitted he had.
Yes, sir.
It's not illegal to drink alcohol and then drive if you're not intoxicated, right?
Correct.
Are you a drinker?
No, sir.
You don't drink any alcohol?
No, sir.
Okay. Do you think everybody that drinks alcohol and then drives is guilty of DWI?
No, sir.
So you said you were out that night as a speed, to look for speeders?
It was a traffic enforcement, yes, sir.
I think you said you were out there looking for speeders
Yes.
and also drunk drivers.
Yes, sir.
So you were like the speeding and drunk driving.
Hold on. Let's break this down. We have a .025 BAC plus marijuana and cocaine in her system, an unopened beer in the driver's seat, and a fatality. But here's the legal twist. Prosecutors are saying there's a causation issue. That means they're struggling to prove beyond a reasonable doubt that her intoxication directly caused the death, which is required for intoxication manslaughter. So instead of a felony manslaughter charge, we're looking at a DWI probation deal. Now here's the tension. Should intoxication alone be enough when someone dies? Or does the law require that strict causal link for a reason? Drop your thoughts below, because this is where law and emotion collide.
Enforcer that night.
Correct.
Are you familiar with the saying that when you're a hammer, everything looks like a nail?
True.
So that was kind of your role that night. You were out there looking for, it was the night shift.
Yes,
You're
sir.
looking for people to arrest or pull over for DWI, right?
Correct.
And you happen to find someone who looked like a nail. He was speeding and you smelled an odor of alcohol, right?
Yes, sir.
Now, you wrote an office report in this case, correct?
Yes, sir.
And you wrote that close in time to when this happened, right?
Correct.
You bring a copy of that with you?
Yes, sir.
Okay. I saw you kind of looking down earlier. It's okay to refresh your memory
Mhm.
because I know it was a little time ago, but can I just ask you, you don't read directly from it
Correct.
word for word, but I mean, if you say, hey, do you mind if I refresh my memory? That's fine, okay?
Okay.
You stated that you smelled an odor of alcohol on his breath.
Yes, sir.
And that was when the state was asking you questions right here.
Mhm.
You didn't say I smelled a strong odor of alcohol.
Correct.
You didn't say I smelled a heavy odor of alcohol. You just said I smelled an odor of alcohol,
Okay.
right?
Yes, sir.
You could have said, when they said, what did you smell? You could have said, I smelled a strong or heavy odor of alcohol on his breath, right?
That's correct.
But you did not say that.
That's correct.
But you'd agree with me anyway, though, that just having the odor of alcohol on your breath, that doesn't prove a person's intoxicated.
That's correct.
Everybody knows that, right?
Yes, sir.
It doesn't even tell you how much alcohol a person has consumed, right?
That's correct.
Even if you said a strong odor of alcohol, that doesn't mean that, well, that person's really consumed a ton of alcohol, right?
Correct.
Okay. So he admitted to drinking. You smelled the odor of alcohol. That makes sense, right?
Yes, sir.
Okay. Him drinking and him admitting to it and you smelling it, that doesn't mean he was intoxicated though, right?
That's correct.
Okay. Now, I don't know who's, I mean, I'm 53, my hearing's not what it used to be, but he didn't say I had several. We didn't hear that. Are you telling the jury that that's what you heard? How old are you?
I'm 50.
Do you wear hearing aids?
No, sir.
Do you have trouble hearing? Has any of your family?
Sometimes in a close room, yes.
Okay. Family members ever said something like that, like they have to me, that you have to repeat themselves?
But sometimes.
After listening to it, I think once or twice, are you still trying to, I mean, you're under oath here, right?
Yes, sir.
And you're still telling these folks here that we all heard that he said, I had several drinks? Or do you want to change that answer now? Just tell us the truth. He never said several drinks.
Okay, correct. Yes, sir.
Well, they got this man charged with a criminal offense. You understand that?
Mhm.
If you were charged or a family member, would you want an officer up there not telling the truth to a jury?
Well, in.
Objection,
No,
Your Honor.
No, sir.
No, sir. Is that your answer?
Yes, sir.
So why is it okay for you to do that? You said it wasn't the truth.
No, I never said that, sir.
Did he say several drinks?
He said a few, yes.
Did he say, I had several drinks? Like you testified to under oath 2 times.
Yeah.
That's an answer, Judge.
Overruled.
Which is it? Because you just said no, he didn't say that.
No, he said few.
Is that fair to exaggerate facts or to tell the jury things that are not true?
No, because a few means several.
But he never said several. He
No,
never
sir.
said a few. You play it again? I'll play it as many times as you want. Can you, if I played it again, can you point out to the jury where he said I had a few drinks? Officer, look, I'm not trying to trick you.
Mm-hmm.
This is important. We want to be fair,
Yes, sir.
right?
Yes, sir.
We want to be fair, right?
Mm-hmm.
Your job's too important to not tell the truth under oath, isn't it?
That's correct.
I mean, is it that important that you've got to exaggerate and make up things that aren't true just to try to convict this guy?
No, I'm not trying to convict nobody.
Well, then why aren't you telling the truth to the jury? We all heard it.
The video showed the truth.
Right. The video shows the truth.
Yes, sir.
You asked him if he had been drinking.
Yes, sir.
He said a little bit. Right?
I need to go back and see the video.
Really? It's not important to you? Did you watch the video before testifying?
Yes, I did, sir. Yes.
I just wanted to be clear about what happened, and we have the video, and then we have what you're saying the video said, and those don't match up, do they? Yes or no? Is what you told the jury match up with what is on the video?
No, sir.
How is that okay? That's not okay. You went up to him and you asked him, have you been drinking? And he said, a little bit, right? I will play the video again. It's in evidence. Do I need to, or will you just agree with me that that's the truth? Because if you're not going to agree with me that that's the truth, you want me to play it again?
Sure.
You guys mind? Help me drive.
Your Honor, for the record, that's State's Exhibit 2 at the 2-minute 34-second mark.
Mr. Martinez, he's supposed to start going 100 miles an hour. Going home? Where you coming from? Over? 59? We got anything to drink tonight? Little bit?
You stop right there. What, you said how much did he have to drink? Have you had anything to drink? What did he say?
A little bit.
A little bit. He didn't say a few, correct?
Correct.
He did not say several, correct? Okay. So that's not a part of this case.
Correct.
Okay. Go ahead. Thank you.
Mr. Martinez, this week,
And Your Honor, for the record, this is 6 minutes, 33 seconds. State's Exhibit 2. 6:32.
Mr. Martinez, how much did you have to drink alcohol during one? Only one? Okay. The reason why I'm asking is I can smell the alcohol.
You came back to the vehicle. You asked him again, how much have you had to drink tonight? And he said, 1. And you said, are you sure? He said, yeah. He didn't say a few, right? He never said several, correct?
Correct.
Is there anywhere else on the video that he said a few or several?
No, there's a part of the video where it says honestly, yeah.
I'm sorry?
There's a part of the video where he says honestly,
He said,
yes. Honestly, yes.
yeah.
Or yeah.
Well, that's why I wanted to show you what the state showed you. And the answers that you gave don't match up with what Mr. Martinez said, right?
Correct.
Okay. We heard you ask him 2 times about drinking.
Mm-hmm.
Did he ever say he had a few or several?
No, sir.
But then why would you come to court under oath and tell the jury that? Why? That's, may I approach the witness, Your Honor? I've got copies of your offense report.
Yes, sir.
I'd like to show them to you. I don't know what you have, but you wrote in your office report, right, that you asked the driver if he had any alcoholic beverages, right?
Yes, sir.
We heard that. That's the whole purpose of that on body cam, right? So we see the truth. That's the truth.
Right.
Not what you're saying, right? Right?
Yes, sir. Right.
And he stated, what did you write? He had only 1, and you put O-N-E, and then you put parentheses and the number 1 in there to make sure that there was no confusion in your office report that he said he had 1 drink.
Yes, sir.
You never wrote anywhere that he had a few or several, or that he came back later and said, well, honestly, I have more to drink. Is that it? Anywhere in there?
No, sir.
Is this the kind of police work that you are used to getting away with doing?
No, sir.
So you don't get away with this all the time?
No.
Or you do get away with it all the time?
No.
Yes or no? Do you get away with writing false office reports?
Let's move on.
On the back, you write again that you asked the driver if he had any alcoholic beverages. That's like 2 places. And he stated that he had only 1.
Yes, sir.
And you wrote the number 1, O-N-E,
Yes, sir.
and then you put parentheses, the
No.
number 1. Period. Anything about that I misrepresented?
No, sir.
You approached the vehicle and he was holding his license and insurance out the window.
Yes, sir. Correct.
You were going to ask him for that, right?
Yes, sir.
How in the world is that a sign of intoxication? You said he was bouncing it?
Yes, sir.
That's a sign of intoxication.
Usually drivers.
Is that a sign of intoxication?
No,
Yes
sir.
or no?
No,
Then why are you here trying to tell the jury that it is?
I never said that.
Do you remember 10 minutes ago when they were asking you questions and you said he was bouncing his license and you were trying to insinuate that that was weird or some,
That was an observation.
right, about like his mental or physical faculties?
Yes, sir.
So okay. You talked about NHTSA, right?
Yes, sir.
I know this isn't the manual you received, but National Highway Traffic Safety Administration, that's NHTSA, right?
Yes, sir.
That's an acronym that stands for the federal agency that is the authoritative body on how to administer field sobriety tests, right?
Correct.
And they give you an arsenal of 3 tools, 3 tests. There's an eye test, the horizontal gaze nystagmus, right?
Yes, sir.
You know the name of the other 2?
Yes. Walk and turn, one leg stand.
Okay. 3 tests that you can use to administer, and as you said, to determine if a person is intoxicated or not, right?
Yes, sir.
And that's what you were intending to do. You smelled alcohol. You asked him if he would do those sobriety tests.
Yes, sir.
And he said no. People have the right to refuse those tests, right?
Correct.
And he invoked that right.
Okay.
He thought about it. He made a conscious decision and said no, right?
Yes, sir.
Which he has the right to do.
Yes, sir.
Now, what you decide to do if somebody refuses, that's up to you, right?
Yes, the National
Correct.
Highway Traffic.
It's up to
and
you.
Safety Administration.
Objection that's non-responsive, Your Honor. I asked a yes or no question.
Both of you guys just don't get hostile. Ask the question, let him answer it. That's it.
Objection non-responsive.
What's your question?
I said if he refuses or submits if he refuses, what you decide to do next is up to you.
Yes, sir.
Okay. So you intended to perform those tests, as you stated, to determine if he was intoxicated or not, right?
Correct.
But you were not able to perform those tests to determine if he was intoxicated or not, correct? You stated that, so in your training, you went through, you received a manual about the standardized field sobriety test, right?
Yes, sir.
And that talks about the history of alcohol in the country, administration of the field sobriety tests, but also a whole list, a litany of signs about how a person's driving that could also indicate intoxication, right?
Yes, sir.
I mean, there's 100 different clues they list that say if a person is driving like this, that could mean they're intoxicated.
Correct.
Did you know that speeding has never been one of those signs?
This is speed.
Speeding. Did you know that speeding has never been listed as one of those signs?
It says speed and braking.
Is everybody that's speeding intoxicated?
No, sir.
Only at night
No,
when
sir.
you're out there looking for drunk drivers.
I'm not looking for anyone.
Well, that's not what you said earlier, is it? You said you were out there looking for speeders and drunk drivers.
No, I was doing traffic enforcement.
Mr. Martinez, there's no evidence that he was swerving, correct?
No, sir.
You didn't testify to that, right?
No, sir.
You testified to everything you observed about his driving to the jury,
Yes, sir.
which would indicate that you thought he might be intoxicated, right?
No.
You didn't keep anything back, right? He wasn't running red lights, stop signs, swerving all over the road, right?
No, but he did a moving violation. Yes, sir.
Right. We all know he was speeding.
Correct.
That doesn't prove a person is intoxicated, right?
No, sir.
I don't know if you saw your your radar in there, but all those people that were, well, when you pulled him over, there was nobody around them. There were a few other cars that passed. Your radar kept going like 77, well over the speed limit.
Yes, sir.
All those people intoxicated just because they're speeding?
No, sir.
Okay. We know that that was a traffic violation.
Yes, sir.
Was there anybody that called in, like to 911, there's a drunk driver out there?
No, sir.
With respect to Mr. Martinez?
No, sir.
So other than just driving fast, there was nothing else about him driving that indicated to you intoxication?
No, sir.
Okay. When you pulled over, some people who are intoxicated, they keep driving for a long time before they pull over, right?
Yes, sir.
It shows slow reaction time, right?
Yes, sir.
There's nothing about how he acted that showed a slow reaction time. He put his blinker on, he pulled over, right?
Yes, sir.
Nothing about the way he pulled over indicated intoxication, correct?
No, sir, but he did straddle the yellow line.
Yeah, we heard you say that.
Mm-hmm.
Your opinion, because he pulled over to the left instead of the right,
Yes, sir.
that's not how you wanted him to pull over, right?
That's a safety.
Did you get on your bullhorn and say, driver, pull over to the right shoulder?
No, sir.
You could have, right?
Yes, but due to the
Yes?
lanes, safety. Yes, sir.
You could have told him where you wanted him to pull over.
Yes, sir. I agree.
But you followed him, you put his blinker on, pulled over to the left, and that's where you stopped him. And then Officer Ponce, or was he your corporal at the time?
Yes, sir.
He actually showed up after you, and he helped block the scene,
Okay.
block that lane so it was safe.
Yes, sir.
He was out on the scene as well,
After the fact, yes, sir.
and he observed Mr. Martinez as well, correct?
Correct.
Now, I don't know how closely you watched the video, but you know that there's more things that you said that are not true when the state asked you questions. Do you know what those are?
Remind me.
Well, I mean, you wrote in, and you have your offense report, and Officer Ponce wrote a supplement, correct?
That's correct.
Okay. And Officer Ponce, is that how you pronounce his name, Ponce?
Yes.
He wrote what he observed of Mr. Martinez, right?
Correct.
You stated to the jury that you observed Mr. Martinez chewing gum.
That's correct.
Okay. Look through your offense report and point out the place anywhere in there where it says that you observed Mr. Martinez chewing gum.
No, I didn't have it to my report, no, sir.
It's because you didn't notice that. Officer Ponce did. Officer Ponce comes out, and he even, so you told the jury, they said, what else did you observe? I observed Mr. Martinez chewing gum. And then that was a sign he was masking, hiding that he was intoxicated.
Yes, sir.
Really? Really?
Yes, sir.
Officer, you didn't even know he had gum in his mouth. Officer Ponce comes out. I mean, eventually you did, because Officer Ponce told you, right?
No, I didn't notice the chewing gum.
Where is it in your offense report? Show me. Just show me.
Put it.
Where's it on the video that you observed gum in his mouth? Officer Ponce comes out. He asks you, did you watch this part? He asks you, does he have gum in his mouth? And you said, I don't think so.
That's a hearsay at that point. He's asking about another person. He's not going to hear. It's all
This goes towards credibility, Judge, what he testified to earlier.
He's asking about somebody else's statement out of court.
I mean, I can ask what happened. That's.
Here's a question.
You weren't, you didn't notice gum in his mouth. The other officer asked you and notified you. He had gum in his mouth, right?
He did advise it, yes.
Right. And at first you weren't aware. And then Officer Ponce goes up to the car and tells Mr. Martinez, open your mouth, right?
Mm-hmm.
You saw that, right?
Mm-hmm.
And Officer Ponce looks in Mr. Martinez's mouth and he says, spit your gum out. You're not allowed to have gum in a patrol car, right?
Correct.
You didn't have any part of that. If Officer Ponce hadn't even observed it or asked him to open his mouth, you would have never known. But you're here today representing things to the jury that they're totally not true. I mean, the gum's an insignificant part, right? mean, you're not trying to convict a person because he had gum in his mouth for DWI, right?
I'm not trying to convict anyone.
You're not. So you're here like testifying in a neutral capacity? Or are you biased against Mr. Martinez?
I'm biased, no one.
Unbiased.
Unbiased, no one.
So you're here in a neutral capacity?
I'm here just representing.
Okay, so if the jury, who decides whether or not it's guilty or not guilty? You or the jury?
I believe the jury.
Right. When you arrest a person, that doesn't mean that they're guilty of an offense, right?
That's correct.
You just had probable cause. I mean, it sounds like there may be a question about whether you even had probable cause, right?
Just a little repeat.
Your Honor, that's a legal conclusion at that point.
He was earlier making legal conclusions, was he not? Overruled?
I guess my point is that probable cause, you smell alcohol, you pull someone off the road, it's probably a safe thing to do, right?
Yes, sir.
If the jury says they don't think that it was proved in this case, they can say not guilty, right?
That's correct.
And nothing would happen to you professionally in your job if they said not guilty, right?
That's correct.
And since you're neutral and not biased against Mr. Martinez, whatever the jury decides, you would be completely fine with, correct? You say you're not here trying to convict them. If they said not guilty, you should be completely fine with that.
That's correct.
That's correct.
Mm-hmm.
So it's fine for whatever the jury decides, you'll be totally fine with.
That's an answer.
No, I'm curious as to, was there slurred speech? Were there bloodshot eyes? I'd like to know about the indicia of intoxication.
That's about where I was going next, Judge.
So
I'll get there. Sorry. Yep.
get on it, doggone
it. So let's talk about that. The state kind of concluded by they asked you, which is typical. Did you form an opinion about whether or not Mr. Martinez was intoxicated?
Yes, sir.
And you said, well, first of all, you said that he had slurred speech.
Yes, sir.
I mean, there's like less than 1 minute, maybe, or a minute of you talking to him. We don't hear any slurred speech on the video. I'm sorry.
I heard it.
On the video.
Yeah.
Seriously?
On the video when I was there.
You said you had quick answers. I mean, what's the opposite of that? Having slow answers?
Sir, quick answers to stay quiet. Yes, sir.
Well, if he was responding slowly, you'd say he was intoxicated because he had a slow reaction time in responding to your questions.
I never said he was intoxicated. I said he had signs of intoxication.
You never said that you thought he was intoxicated. That's the point. Because when the state asked you, what did you think about him? You said, I thought he didn't have his mental faculties, right?
Yes, sir.
And they said, why did you think that? And you said, because he said, I'm coming from 59.
Yes, sir.
Perfectly clear. We could all hear it. No slur speech. No speeding it out with a quick answer. Perfectly legible. I'm coming from 59. And that means that he didn't have his mental faculties?
The answer that he gave.
From 59?
Yes, sir.
That's what you're saying is evidence that he didn't have his mental faculties?
Yes, sir.
I think you said because he didn't say I was coming from a restaurant or a bar, you wanted him to say he was, I mean, whatever. And that's something you based your decision to take him into custody on?
No, sir.
Well, when the state asked you, what did you base your decision on? And that was one thing you said, right?
Mm-hmm.
Okay. Physical faculties, you stated that his balance was bad.
He stumbled when he stepped out of the car. Yes, sir.
Where? It's like we're watching two different videos. Where was his balance bad? Where did he stumble? Did we ever see that?
Yes, he did.
We did?
When he was coming out of the vehicle, He kind of like stumbled.
Dude, the guy gets out of the vehicle, he turns around like this and puts his hand on the car. Where in the world could he stumble in 1.5 foot space? He did not stumble.
That's what I observed.
I'm sorry?
That's what I observed.
You saw him stumble from the time he got out of the car to put his... You had a dash camera too that was in your car. So if he stumbled, there's a whole other camera that would show that, right?
Yes, sir.
Why didn't we see that? Why don't we see something that shows what you say is true?
That's not the real percent.
Whose job is it?
Unless,
I think you're putting them in a bad spot, don't you think? They're trying to prove what you say is true, but they can't. Don't you see that? They can't prove that he said he had several drinks or a few drinks. They can't prove that. You're making their job very hard. You get that? Is there something else you want to give them to help them prove that you're telling the jury the truth?
but it's all there.
It's all there.
Yes, sir.
None of us just see it. It's all there. He had glasses on when he was sitting in the driver's seat. You see that? But you're saying that you noticed he had glossy eyes
Yes, sir.
in the few seconds you looked at him?
Yes, sir.
Did you know that, glossy eyes is not a sign of intoxication at all?
No, sir, it's not.
You agree with me? Are you agreeing? I don't know. Look, I don't know what you're agreeing to or what you're not. Are you agreeing with me that I'm right, or are you arguing with me that I'm wrong?
No, red bloodshot eyes is glossy eyes.
I didn't ask that. I said glossy eyes through his glasses. Did you know that according to your NHTSA training, all the clues, glossy eyes are not a sign of intoxication?
That's right.
So you're agreeing with me?
Yes, sir.
So why in the world would you write that and try to tell the jury that's another sign of intoxication you're telling them? It doesn't even prove intoxication. Why? Why are you doing
I
this?
never said that glossy eyes proves intoxication.
They asked you to list. We're taking notes over here, right? You see us over here, we're writing things down. They asked you what signs, more than one time. Slurred speech, which we didn't hear. Glossy eyes. You said that. Are you saying now you didn't say it?
No, I said it.
Okay. You know that's a vital sign of people being alive. You have liquid on your eyes. If you don't, there's a real problem. You ever thought about it that way?
Not medical.
Well, then why are you trying to tell these folks that there's things that you probably didn't even see and trying to tell them that meant he was intoxicated? Doesn't sound like you're being real fair or neutral to me.
I never said that he was intoxicated.
You never did.
No, sir. The only thing that I
But
said
you
was
put
that
him
he
in-
refused the SFSTs, which that proved to me that he was intoxicated, hiding evidence of intoxication.
Okay, you never said he was intoxicated, but he refused the SFSTs, and that said he was intoxicated. I'm just repeating what you just said. Have you ever heard the saying, if you tell the truth, you don't have to remember what your answers were, or you don't have to remember what you said?
Right. That's correct.
They kept asking you to tell us your opinion about what did you base your decision on, and you cited 59 for mental faculties, physical faculties. I mean, we didn't see any stumbling. Glossy eyes are not a sign of intoxication. I think you even said droopy eyes, didn't you?
Yes, sir.
I wrote that down.
Yes, sir.
For God's sake, show me where you wrote droopy eyes in any of your offense reports, probable cause affidavit, blood warrant. You called it in on your MDTs. Show me one place where you said when you wrote this offense report after this arrest that he had droopy eyes. Show me.
Listen to the report, no, sir.
First time ever today. You just thought you'd throw that in there?
No, sir.
Well, you did. You did. Yes, you did. You just decided you would throw that in there. Because you did throw it in there.
Okay.
Did you ever tell anybody that before today?
No.
You know, there's a picture of his mugshot that they have in color. This is black and white. If he's got red eyes, droopy eyes, wouldn't you want to show the mugshot in color to prove to the jury what you're saying is true? That'd be pretty powerful evidence, right?
Yes.
You've probably been in it. Have you ever been in a trial before?
No, it's my first time.
There was no alcohol in the vehicle? That was a question.
No, sir.
The state asked you a question. Did you form the opinion of whether or not he was intoxicated? You stated I wasn't able to do, or you weren't able to do the field sobriety test to determine if he was intoxicated or not, correct?
No, I just said that he refused the
Right.
SFSTs.
Right. I'm saying you were not able, you said you do the field sobriety test to determine if a person's intoxicated.
Correct.
You were not able to determine if he was intoxicated.
Correct.
And you have stated twice or more, you never said you thought he was intoxicated.
Correct.
Okay. Okay. But you arrested him, put him in cuffs, and he was in custody. You even called it in on your radio, one in custody for DWI.
Yes, sir.
But you didn't think he was intoxicated. Correct?
Correct.
Judge, I've asked everything I can. I object to the, I don't know what else.
Okay.
Pass witness.
All right. May this witness be excused?
Yes, sir.
Yes, sir.
Okay. Thank you so much for coming and testifying. You're excused. Say nothing.
Are they subject to recall?
I'm releasing him.
I think it's a good time for a break. Would you mind taking the jury out?
All right, sure.
Let me get.
All right. Please be seated. Tyler, you said we had a motion.
I have a motion to suppress the arrest. No probable cause. I mean, I think there's no credibility at all with this,
I'm going to grant it. I'm going to grant this motion.
and all the evidence that came after the arrest.
Bear with me 1 second. Let me go to the potty. I'll be right back.
I wasn't.
So her bond is set currently at $1,001. She doesn't have any ability to make bond. From kind of going through the procedural background of the case, it sounds like she'd gotten a GOB bond originally about a year ago.
Wow, she's been gone that long.
Well, did not come to a setting and have a chance to meet you, Judge. And so, because had she have gotten an admonishment from you, she'd have certainly attended.
Good try.
Can
you bring up Ms. Johnson, please?
She does not have any criminal history, and this is kind of a DWI. I've chatted with them briefly about it, but the allegation is that the police found her asleep in a parked vehicle at a gas station, and with the car in park, but they say armed.
I've
So-
done the research. We had this issue not a week ago, and I'm telling you,
Well, it's sufficient from a legal sufficiency standpoint. It can stand, but what do jurors think?
I combed through like 20 cases. Give me a second.
Yes.
Stephen. Hey, hi, Stephen. Hey, I'm in the middle of talking. Give me maybe like 10 minutes. I'll call you right back, huh? No, it's okay. I'm super excited to talk to you. Give me 10, huh? Okay, bye. We did the diligence as far as that argument is concerned. My only concern now is that she's been gone for how long, but for this, she would still be wherever she is, right?
Well, she's got a kind of difficult financial situation. She doesn't have, she got family, but she's talked to her family and doesn't have the ability to make even what would be roughly paying $150 to get out. And, but she's 43 with no criminal history. She's got 2 children that she successfully raised to their young adults.
Come up, ma'am. You were Tammy Johnson. How's jail? How's jail?
Different, Judge.
Why do we have jails?
Criminals off the street, I guess.
Yeah, that's a good reason for sure. Why else?
Judge, she knows.
To make sure you come back. And when you don't, the sentences get longer, the bars get colder. Just, you know that when you fail to appear, your bond's at $1,000 right now. So all that needs is $100 and you're out, $125, you're out. You now know that you have no one to pony up that kind of money, no one to pony up that kind of money to get you out. Mr. Garris is asking me to let you out. The only reason you're here now is because you got busted. Otherwise, you'd still be out who knows where. Why would we let you out? You tell me.
She wants to move forward and deal appropriately with the case, and the state has given me quite a bit in the way of discovery to review. And as with any type of blood case, there's probably going to be more that we venture out to seek, but it'd be obviously sometime. We talked about it, the idea that these can take 6 months, 7 months to even get ready to see if it's a viable case for trial.
Therein lies the problem where, ma'am, you sit now in custody until the case is either pled, you're in trial, or somehow gets disposed of. That could take 6 months. Where have you been?
I'm trying to get my life together.
Judge, she's worked for a long time as a waitress and is living, and she's living kind of difficult situation at the moment. So it's experienced bouts of homelessness but now has a more stable situation. She has the ability to get to court and will be here. That's the representation we're making to the court. And I think we can do short resets if you'd like.
You know, Mr. Garris, I never want to leave someone in custody. But one of my primary concerns also is not putting someone out on the street. And I'm telling you now, I'm willing to give you another chance. But I'm not gonna put you out on the street if you ain't got nowhere else to go.
She does now. She's living in she has a motel that she's living in down, kind of temporary housing.
Yes, it's permanent. It's been for a while.
I don't believe that for a second. Who do you have in your life that's willing to take you in?
I've got that information. Yeah.
Before I had no one, but now I do.
But he just doesn't financially have the ability to.
The only thing that's changed between now and then is you got arrested. Ms. Johnson, the last thing I want is you to be put on the street where you look like you're going to start using again, because I don't want you to use. If I were to drug test you now, what are you going to test positive for?
Discussion about that.
Here's the drug. I'm going to drug test you like crazy. And if I find that you're using, then I'm going to keep you. And I'm not going to play this game. You can't even look at me in the eye.
Drugs aren't a problem.
Stop. Don't. Okay. At this point, Judge, I'm going to admonish my friend.
It's okay. That's all right.
So,
where do you have to go?
Judge, let me answer all the questions. She lives in a motel, stable situation, can make her way back to court. And you can do short resets and we'll be here. And that's the understanding that we've talked about, and I think would be appropriate at this time would be to give her a chance to come in, and obviously we'll comport with all the requirements that this court installs. And if we have to do testing, we'll do that.
Let me make something perfectly clear to you, Ms. Johnson. I don't like it when people plead guilty just to plead guilty to get out. I'm not down with that. And we're not going to play that game here. So if I let you out, I expect several things from you. Number one, that you're not going to endanger my public. That's the first and foremost. Number two, that you're not using alcohol and or illegal drugs. And I'm telling you, I'm going to test you like crazy. If you can't stop on your own, then we will do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Sure.
Number three, if you don't have a license and liability insurance, you are not allowed to drive. Do you have a Texas driver license? Then you will be signing with me today an affidavit. This is a promise you're making to me that you're not going to drive. And I don't care if Jesus needs to ride to church. You get into a car and drive. I can have a contempt hearing and you'll be facing 6 months every time you drive. Do you understand? Do you want me to give you a PR bond? Can you stop using?
Yes, sir.
I'm going to let you out and I'm going to have you come back here on Tuesday. And I want you to come back and take a test on me on Tuesday. And I want to know for sure. You got to understand, you've played Monopoly, right? What do you get in Monopoly to get out of jail? What do you get? You get a get out of jail free card, right? This is the only one you're going to get. You're not going to get another one. Do you understand? So I will let you out now, but I expect you to comport and comply with conditions. And that's it. I'm not asking for much. I'm just asking you to be sober and come back to court and stay in touch with counsel. That's all.
Thank you, Judge.
Of course. Now, we will set her for Tuesday. She got to come back here Tuesday. You don't come back, a warrant will issue, and we're going to just play the 6-month waiting game while you're there. Because I'm telling you, I don't accept pleas just to get out of jail. All right.
Thank you, Judge.
Thank you.
All right, thank you.
Thank you.
She can't go yet, though. We need her to sign conditions with, yeah. Mr. Gamble, Mr. Payton, gentlemen, both of you are charged with cases in here. Both of you are charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You know, looking at your information, I see that Mr. Payton, both of you guys, and Mr. Gamble are also charged with aggravated robbery with a deadly weapon. However, your felony bond was $10,000 and yours was $70,000. I don't understand why. We will soon find out. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On November 7th, 2024, the officer conducted a traffic stop on a motor vehicle after observing it violate Texas Transportation Code 547.602, which requires mirrors, and the officer confirmed 5 traffic citations. The driver was placed into custody for those citations, and the defendant, Payton, was sitting in the front passenger seat where a black extended magazine was observed in plain view between the defendant's feet. Defendants 1 and 2, the second defendant being Gamble, were both detained, and a probable cause search revealed a black backpack found to be concealing 2 semi-automatic pistols with a loaded round in the chamber, not in a concealed holster, and within the wingspan of both defendants, as well as 37.8 grams of marijuana.
Tell me about the ag rob.
So the ag rob for Mr.
The
Payton,
defendants, same day on 11/8.
I just want to confirm, Your Honor. It looks like the ag robs are different days. For Payton, it's July 27th, and then for Mr. Gamble, it's August 26th. So they're 2 separate incidents for aggravated robbery. So to begin with Mr. Payton, the aggravated robbery on July 27th, an officer was dispatched to a robbery at a vape time store, and the complainant said an unmasked defendant came inside the store, and the complainant buzzed him into the door. The defendant looked around and then walked to the door and let 3 other masked men into the store. One of the 3 men pointed a gun to the left side of the complainant's neck, and then the other 3 men took money and merchandise before running from the door. The surveillance video showed the incident and showed defendants leaving in a silver Kia sedan. Officers were able to trace the sedan back to a co-defendant. They were also able to see that the Kia had been involved in a prior traffic stop. In that stop, the passenger of the car was viewed in the officer body-worn camera. That person was the unmasked first person who entered the store and let the other 3 men into the store before helping take cash and merchandise. And to move on to yes.
There were multiple, I think it was this defendant, Mr. Gamble, was one of 5 suspects robbing vape stores. And there are multiple incidents of the robbery. So we can certainly read PC, Judge. It's just very long, but we're happy to read it.
Is it the same MO where it's in, I mean, are we talking about just like an enterprise type situation? Like an engaging and organized? Okay.
So
I'm just, I give my question is I want to know how dangerous these guys are, and obviously we've got ag robs on both of them, perhaps even multiple stops of ag robs. So Mr. Payton, I'm going to find that there's probable cause to go forward with the case. I'm now putting an ankle monitor on you, and I want to know where you are at all times. And I'm giving you a curfew of 7 p.m. to 7 a.m. I don't want you out in the middle of the night, and I'm barring you from going to any, just got to be careful in this life, man. You got but one. You end up with the wrong person. You hang with dogs to get those fleas. You're going to end up with a 40-year sentence back there. And I'm going to tell you now, living in a 6x9 for 40 years is no way to live life. You know what I mean? It's not. I'm also ordering you not to be in possession of weapons, not to consume alcohol or illegal drugs. If I find that you're smoking weed, you're using anything like that, I'm going to put you in jail. I'll deem you a public danger, and I'm going to make your bond so freaking high. Do you understand me?
Yes, sir.
How old are you?
17.
What do you do for a living?
I'm employed right now.
Why?
I'm trying to get my.
I'm now making that a condition of your bond as well. You and I are going to be so close, it's going to be ridiculous. I am making it a condition of your bond that you get your GED, and I'm going to bring you back in 2 weeks to see what you have done to get your GED. You need to start working on it. We have enough people in custody as it is, and what you do now will affect you for the next 40 years of your life. You start acting like a knucklehead out there, you're either going to be dead or with a 50-year sentence, and that's not a way to go through life. Do you understand? I will appoint your lawyer today.
And Your Honor, in regard to Gamble, it appears that the bond may be higher as officers presented the facts of both the current case as well as a separate case that's unfiled. It's an HPD case to which the defendant confessed to also being involved. So it seems there's also an ongoing investigation.
Do we know who put the gun to the neck?
It was the defendant as well, defendant Gamble.
Gamble.
And he also put a gun to the complainant's face as they were stealing marijuana and other items.
You hear everything I just said over there, Mr. Gamble? Same thing applies to you, man. We have enough black and brown people in custody as it is. We don't need any more. You don't need to live life with a 40-year sentence because of some stupid chisa, man. You know? Do you know if you're going to bond out? I'm going to be talking to this bond later, Judge. So okay, if you bond out, I'm ordering you under home confinement. I don't want you out anywhere. Do you understand? You will get a GPS monitor on your ankle, no weapons. I don't want you to talk with any of the co-defendants in any of these cases. I don't want you to